Greetings of the day. Today, in the session 2 of the Industrial Dispute Act, where I am going to discuss with you about the settlement machinery and the authorities under the Act. The objective of the session is to provide you the clarity of the settlement machinery, how the Work Committee, Board of Conciliation, Labour Court, Conciliation Officer, Court of Inquiry, Industrial Dispute, Industrial Tribunal, they work. Now, let me discuss with you all these machinery tools. Settlement of machinery. The authorities under the Act are Work Committee, Board of Conciliation, Labour Court, Conciliation Officer, Court of Inquiry, Industrial Tribunal. Work Committee. Work Committee under Section 3, where in case of any industrial establishment in which 100 or more workmen are employed or have been employed on any day in preceding 12 months, the appropriate government may be there by journal or special order require the employer to constitute a work committee. So the number of representative of the work committee in the or of the workmen in this committee shall not be less than the number of representative of the employer. The representative of the workmen shall be chosen in the prescribed manner from among the workmen engaged in the establishment and in the consultation with their trade union. Board of Conciliation. Before that, it is very important to understand who is Conciliation Officer. As per the Industrial Dispute Act 1947, the state and the central government can appoint Conciliation Officer to mediate in all dispute brought to the notice. The appropriate government has been empowered under the Industrial Dispute Act to appoint such number of persons as it thinks fit to be Conciliation Officer. The government appoints such officers either for specified area or for specific industries in specific area. The appointment is made by notification with official gazette, either temporary or permanently. But keep this thing in your mind. Here the officer enjoys the power as a civil court and he is expected to give the judgment within 14 days of the commencement of conciliate proceedings. Now, Board of Conciliation. As per the Section 5 of the Industrial Dispute Act 1947, the Board of the Conciliation is not a permanent institution like a conciliation officer. It is an ad hoc tripartite body having the power of civil court, created for a specific dispute, which considers chairman and 2 of 4 other members nominated in equal number by the parties for settling of dispute. Here the chairman, who is appointed by the government, not connected with the dispute or with any industry directed for the dispute, right? So this is your Board of Conciliation. Now, the Court of Inquiry. Court of Inquiry is as per the Section 6, where in this the proceeding fails to resolve a dispute. If in conciliation proceeding it fails to solve a dispute, court of inquiry is constituted by the government to investigate, dispute, submit the report within 6 months. Now, the fact-finding body is finding or not binding on the parties to the dispute, but the appropriate government may, as occasion arises by notification in the Gazette, with the court of inquiry for inquiring into any matter appearing to be connected. Right? So here in this way the court of inquiry is there, where in this the court consists of 2 or more member, one appointed as chairperson. But mind it, as I forget to tell you, in this consolation officer, the board of consolation officer, in that case the board is supposed to submit the report within 2 months of the date on which the dispute referred to. Right? Then is your labor code. Labor code, as per the section 7, the appropriate government by the notification in the official gazette constitutes 1 or more labor codes for the adjudication of the industrial dispute related to any matter specified in the second schedule. The courts shall also perform such functions assigned to them, where in this court one person only be appointed by the appropriate government. Right? And appointment, such kind of appointment is known as presiding officer of the labor court. Right? So this is your labor court, and no doubt here the judges of the either of the high court, and here the period is not less than 3 years, has a district judge or a additional district judge held any judicial office in the India for not less than 7 years. So these are the conditions of the appointment of presiding officer. Now is your another one is your work committee. I forget. Work committee. Work committee, as per the section 3, where the industrial establishment in which 100 or more members are employed in a day preceding the 12 months, right, where the appropriate government and with the order, special order, or with that order, they constitute a work committee. Now let me tell you about your industrial tribunal. Right? Now industrial tribunal, as per the section 7A, the industrial tribunal, where it constitute one or more industrial tribunal for the adjudication of industrial dispute in relation to any matter specified in the second schedule or in the third schedule, to perform the functions assigned to them under this act. Now the person shall not be qualified for appointing presiding officer for this industrial tribunal unless he is the judge of high court or is the judge of the district court, but not less than 3 years. Right? But what matters it is about to solve? Wages, including the period and the mode of payment, compensatory allowances, hour of work, rest period, leave with wages, holidays, bonus, profit sharing, rule of discipline, your rationalization, and so on. Right? So these are your the boards and the authorities for the settlement in this settlement machinery. Right? So another one is also there, which is a national tribunal at last, the third one-man adjudicatory body appointed by the central government to deal with disputes at national level for the national importance, and which is likely to affect to the industrial establishment not for less than one state. right? And no doubt here the judge, here the main person who is handling is one person, but not below the rank of the high court judge and not below the age of 65 years, right? Independent person and not below the 65 years. I hope this much is clear to you, and let me go in the